Hello and welcome to this seminar on navigating Section 41 applications and the admissibility of previous sexual history in criminal trials. I chose this topic for the webinar because despite Section 41 now being in force for over 25 years, it remains an area where practitioners struggle with the interpretation of the law and the adoption of the correct procedures in a timely fashion. Indeed, Lord Justice Edis recently described it in the case of Wilson by saying, "There appears to be agreement about only one thing. Section 41 is a highly problematic provision." Part of the problem is that too often applications are made late and fail to properly address the relevance of the evidence to the issues in the case, while the interplay between Section 41 and bad character evidence presents particular challenges. This can result in trials being delayed or, in extreme cases, trials being aborted altogether and the jury discharged, with the ramifications as to costs and the impact on defendants and complainants that this inevitably brings. Section 41 is an issue that often burdens the appeal courts, and there is now a plethora of case law as to the correct approach and scope of the provisions. I've provided a suggested reading list to accompany this webinar. At the end of the webinar, we will look at the future of Section 41 in light of recent recommendations by the Law Commission. For now, however, it remains on the statute books, and so this talk aims to provide a brief overview of the principles of Section 41 by reference to the Youth Justice and Criminal Evidence Act 1999, the Criminal Procedure Rules, and the interpretation of each from key case law. This talk will explore the following. Section 41 as regards the law, procedure, gateways and restrictions. Section 100 of the Criminal Justice Act 2003 in terms of the interaction between Section 41 and non-defendant bad character provisions. The roles and responsibilities of the prosecution and defence when dealing with evidence of previous sexual history.